Well, hello there, and welcome to another edition of the Disability Law Show. I'm John Scholes, alongside Sivan Tumarkin, Tamar Agopian, Samfiru Tumarkin, LLP, the most positively reviewed law firm in the country, here for the next half hour to make you that much smarter. The topic, of course, disability law. It can be an absolute quagmire of confusion. That's why we've been doing this show for so long, and our radio shows as well for many years. You can catch those and find out a station close to you where you can find one. Disabilityrights.ca is a good place to start. You're also encouraged anytime to make that phone call to Sivan or Tamar or their respective teams. You want a lengthier private conversation, 1-855-821-5900, or email, which we'll get to in just a little bit, help@disabilityrights.ca. Lots of things to cover on the show today, guys, including 3 common reasons for an LTD denial. We'll get to that in a bit, but we always kick it off, Sivan, with a case of the day or a week that was, something you've been working on, pal. What do you got?
Absolutely, John. Great to be here with you, with Tamar, with our viewers. Let me start off by telling you about an interesting call I had this week from a gentleman just outside of Calgary, and he called me on behalf of his wife. Now, as a side note, by the way, many people who contact us are not themselves disabled. They're not themselves dealing with their insurance companies or LTD insurers, but are calling on behalf of family members, of friends, of colleagues. And so, you know, the point being that a lot of people who are struggling with their disability, struggling with their insurance companies, just don't have the headspace and are just not, you know, in the position to seek out help. And so anyone out there, if you're watching, you're getting this information, it's good information, think about other people in your life that this may be relevant to. And please, if you need to get in touch with us on their behalf with their consent, we're more than happy to speak with you if you have their consent, of course. So this gentleman called me about his wife, and they're both in their mid-40s. His wife is an IT professional. They have 2 young children, and about a year and a half ago or so, she was in a fairly serious car accident. She was rear-ended from behind by a truck. She suffered a concussion, a few broken ribs. It was not a good situation. She was taken to hospital, and she hasn't been back to work ever since the accident. In fact, not only that, but she has difficulty at home, and she's being followed up not just by her family doctor, but also a bunch of specialists. There is a psychologist involved because she's developed various psychological issues, depression, PTSD, as well as because of the concussion and other symptoms, she also has a neurologist. She cannot work. That's without a question. And in fact, she's getting what's called Section B benefits, which are the no-fault accident benefits that you get in Alberta if you're involved in an accident and you're injured. And so we talked about the accident. We talked about what exactly has been happening with her family, what's been happening with her. And then we got to the reason for why he called me, which is that she recently applied for long-term disability. She has that coverage through work, through her work benefits, and she was denied. And she was denied because of something that we sometimes see insurance deny for, which is, although typically we see insurers deal with this issue later on in the claim. What happened here was that she's under certain types of medications. When the insurance company got a hold of the doctor's files, the clinical notes and records, they saw that one of the medications that were prescribed, she had refused to take. And so they latched onto that, saying that she's not engaged, she's not getting reasonable treatments, even though she is doing other things. She's getting other medications, she's doing everything that her doctors have been saying that she should be doing, but they latched onto this one note in the doctor's file saying that there was a refusal to take these medications. Now, in the absence of context, you would think, okay, well, maybe the insurance company has something here, right? Because there is a provision in every LTD policy that to get LTD, long-term disability benefits, you must be engaged in reasonable treatments. You must be undergoing reasonable treatments. Key word here is reasonable, and of course, treatments. And so when I spoke with her husband, I understood that the medication that she had refused to take is medication for which she was allergic to one of the components of that medication, something very simple. But again, context is important, and insurance companies oftentimes ignore context. They simply see something, the adjuster sees something in the file and says, aha, I have something to latch onto, and I'm going to deny benefits, or I'm going to cut off benefits. And so typically we see these kinds of issues arise during the claim process, during the life of the claim. When somebody's getting LTD, there's a question as to whether or not they are in fact following all of the doctor's recommendations. In this case, this was an outright denial just based on that one single notation. And here's the thing, here's the kicker. The insurance company, the adjuster, never even asked for clarification. Never asked why, never contacted the doctor, never did anything of the sort, simply issued a denial on this very flimsy reason. Excuse. So I explained to him, by the way, I looked at the documentation. I understood, obviously, the context, and I explained to them, look, we can help you here. This is actually going to be a very simple claim to resolve. Even a single letter from me potentially could resolve this, because the insurance company is going to understand immediately that if they don't approve her for benefits, they're going to be on the receiving end of a legal claim, and it's going to cost them a lot more money. Remember, insurance companies, there's one thing they hate more than paying out claims, and that's having to pay their lawyers to defend claims that they know they're going to have to pay at the end. And I'm speaking not just as somebody who's been doing this for many years, Tamar as well, but we both have worked for insurance companies in the past. Trust me when I tell you, they're very cognizant of their legal bills. They don't want to pay their lawyers, whether it's an in-house lawyer or a lawyer at a firm. They don't want to do that. And the other thing I explained to him, obviously, is, look, this is, again, a side note, this was a car accident. We deal with car accidents in Alberta, and we can certainly help his wife and their family also recover compensation that is rightfully owed to them, to her, to the family, for all her injuries and losses because of the car accident. But, you know, that's a different point, obviously, but it's something people out there should know as well, that we do deal with car accidents in Alberta and in Ontario.
Seems like a weak argument.
Absolutely,
like,
John.
Totally. Yeah.
And what's frustrating to me as I'm listening to this is that it's the same pattern time and again that we see. These adjusters love to cherry pick. And they cherry pick. People feel that they're correct in the cherry picking. However, we know as lawyers, having worked on both sides of the fence, when this plays itself out in front of a judge, and it's rare, folks, most of these cases don't get that far into a trial process, but in the ones that have, where the insurance company has cherry-picked information, they've gotten their wrist slapped. Not only do they have to pay someone compensation for all of the benefits that they had denied that was absolutely payable, but this opens the door to damages claims as well. And so look, do we know that in this situation it's going to get to that point? Maybe. Ideally, we're going to be able to get that resolution within months of being retained, really protect all of those rights that she has, both in respect of the Schedule B benefits and the long-term disability benefits. But I think it's important messaging to put out there that just because the adjuster has cherry-picked information doesn't mean they're correct in doing so. And in fact, when we get involved and their lawyers get involved, this is an excellent point of leverage for us to actually get excellent results for our clients.
No, John, one of the things that Tamar said here is, I think, really important to understand. People see TV or they hear stories about other friends, perhaps colleagues, family members that have had cases, and those have gone for years. I can tell you that we resolve these kinds of claims lightning speed within the context of the legal process. Forget about what you see on TV. Forget about Suits. Forget about all these legal shows, okay? Very rarely do these cases actually end up in a courtroom. In fact, most of the time, our clients are hardly involved in the claim process. We're dealing with everything. Our office deals. When we get involved, you're not dealing with the insurance company anymore. You're not getting calls from the adjuster. You're not getting letters from the adjuster or emails. We are now getting all of these, and we're communicating on your behalf with the insurance company. We are collecting all the documentation. If need be, we communicate with your doctors. Maybe there are experts that we need to retain. We'll inform you of everything. We'll explain the process. We'll go through everything and answer all your questions. That goes without saying. But you're not the one that is dealing with this, right? This can be very overwhelming. Some of the stuff we talk about here is very technical stuff as well. You don't need to worry about that. All you need to know is that we can help you. We help people each and every day across the country with their long-term disability claims, and we do it successfully.
You may have caught our sister show with your partner, Sivan Lior, the pocket employment lawyer. It comes from that show, the Employment Law Show. Pocket Employment Lawyer, it's a free and anonymous website. It's about employment law. We refer to it all the time in that show. But Tamar, you're a big fan of this one, right?
I am a big fan of this one because this is something that was conceived of on sort of the employment side of our practice, but we've found it to be an excellent tool also for long-term disability benefits. And here's why. This is a website that you can go to where you can plug in just very basic information about your long-term disability claim, and it will pop out some conclusion around whether or not you may have a basis for a claim for your LTD claim. And at that point, you may choose to then proceed with getting a consultation with one of us, Sivan, myself, any one of our members of our team. Or if you don't want to, that's absolutely fine. You close out that browser and you've gotten some free advice, totally anonymous. We're not going to contact people who go through this website. But we have found, John, that sometimes as a starting point, people really do want to see, okay, what are my rights? Where am I at here? And this Pocket Employment Lawyer is a really helpful tool for that as a starting point to get that information. Because I can tell you, the chips are always in favor of the insurance company. Most of the people that we speak with have never dealt with an insurance company before. Yeah. And so having these tools available to individuals out there for us is at least getting that information out. And as I said, totally anonymous, and people can just really find out whether or not it's really a basis to move forward and have a consult.
Again, guys, pocketemploymentlawyer.ca. You will find that particular portion having to deal with disability law. First email of the show. You want to reach out anytime, not just for this show, but for a radio show or otherwise. It's help@disabilityrights.ca, right? Eden, first one, guys, you can fight over this one. Says, my brother is a project manager in a high-stress position. About a year ago, his health started to decline. He found it hard to concentrate and was experiencing frequent migraines. After rounds of tests, his doctors have yet to find a diagnosis. The insurance company has denied his disability claim, so there's insufficient medical evidence. Like you didn't see that coming. What can he do?
Well, look, I mean, what can he do? I think from a practical perspective, you want to make sure that your doctors are documenting all of those symptoms. Having those symptoms, particularly when you've got a condition like migraines that can absolutely impact your concentration to the point where you can't work, is important to have validated, because it's not something that you can see on a screen or on a scan. It can be very individual and it can be very disabling. And so as a starting point, that's the advice I would give Eden, is make sure that that information is made available to your insurance adjuster as they're contemplating and looking to see what is happening with your disability claim. I think there's a nuance, though, to this, which is it describes for us this idea of having a high stress position, and you tie that with lack of concentration. This is back to basics, Disability Law 101, which is the test to qualify for LTD and continue to get your LTD benefit is if you're totally disabled from your own occupation. If your own occupation is particularly stressful, if the demands are higher than what you would typically see in perhaps a fairly routine type position, then of course when you have issues like migraines, poor concentration, probably associated fatigue and other symptoms like this, then you know that this is going to be one where the adjuster has to take a more nuanced approach in doing the analysis on whether or not you meet the test of total disability. I think it's too easy, frankly, for disability insurers to say, look, you don't have a diagnosis yet, we're not really sure what's going on, so we don't think that you are totally disabled. The courts have said absolutely the opposite, Sean. They have said, look, if you have a series of symptoms and those symptoms in and of themselves impact your function and you can't work, then you should be entitled to long-term disability benefits.
Eden, appreciate you reaching out. Again, help@disabilityrights.ca for you anytime as well. We'll take a short break, then get into our main topic, 3 common reasons for an LTD denial. Stick around for that. In the meantime, that number again, 1-855-821-5900. We'll continue with the Disability Law Show. Hang in there.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Alrighty, welcome back. This is the Disability Law Show. Once again, reaching out to Tamar, reaching out to Sivan and their teams anytime. Make that phone call on your own time. Have a chat, 1-855-821-5900. Email simply help@disabilityrights.ca. Main topic for the show, guys. Let's get into this. 3 common reasons for an LTD denial. We're starting off strong with the big one. You are not considered totally disabled and can still function at your job. We love this one, right?
Absolutely.
John, this is one of the number one reasons that we get. And you know, there's so many others. And I think the first message that I want to send everyone is, no matter what the denial reason is, even if you think that they're correct, even if you think that they are correct for denying you your LTD claim, clearly there was a reason you applied in the first place. So it doesn't cost anything to at least run the denial by us. And I can tell you, John, I've had situations, Tamar has as well, where people have called us saying, you know, we're pretty sure that the insurance company is correct. And by the way, sometimes the insurance company is correct, except that they're not correct they're correct in denying, technically, but it's not sufficient to not have the insurance company pay you. So my point is, always, always, always check. It doesn't cost anything to speak with us. But I digress. So let's go to totally disabled, something we see quite often. People call us, they say, I have a denial letter here. It says I am not totally disabled based on the evidence I have given them. Let's break this down. Total disability, that phrase, totally disabled. The word totally is completely inappropriate. It's an invented term, totally disabled. It's invented by insurers out there. To me, I'll speak for myself. I know James feels that way. I don't know if you feel that way, Tamar.
100%.
It's invented by the insurance industry to mislead the public, to mislead claimants, to mislead doctors, to mislead as many people as possible. Why? Because if you are suffering, let's say, from headaches that prevent you from working, if you suffer from back pain, let's say you can do things around the home, but you can't do whatever the job is that you are doing. You can't do most of the tasks of that job. But again, you can take your kid to school, you can go shopping, do whatever, but you cannot do whatever it is that you need to do at work. You are then totally disabled based on based on how the LTD policy works. But the way you look at it, the way people out there look at it is, well, totally disabled must means I'm paralyzed, must mean that I'm unable to do anything. Total, the word total connotes 100% or close to it. It doesn't mean that. In fact, the way that it should be worded, if it were not to mislead, is, are you disabled from performing the tasks of your employment? That's really what it should say. It doesn't say that, it says totally disabled. The word totally is misleading. But it doesn't stop insurance companies from just issuing out these denials based on this particular denial reason. And people out there, most often when they look at this, they say, okay, well, I'm not totally disabled. Doctors even tell patients, don't bother applying for long-term disability because you're not totally disabled. You're disabled, you can't work, but you're not totally disabled. And so my point is that people out there just give up. They give up the fight before even finding out if they are in fact eligible for these benefits. And so the insurance companies are winning the battle just with this one sentence. They're not even having you put up resistance. I mean, how sweet is that for them? How many claimants have given up on benefits owed to them? How many millions of dollars owing to claimants who have paid for these premiums or had their employers pay for these premiums miss out on these benefits? Just simply because they misconstrue what this term means, because they look at it in the ordinary sense of things, right? They look at it, they see totally, and they figure we're not, we should not be getting benefits. So my point is, don't ever fall for this. Even if you think that you are disabled, even if you think that the insurance company may be right, contact us. Let's have a chat about your benefits, and we can go over your specific claim.
Well played, though. Good verbiage.
Very well played.
Good verbiage.
And it works. Most of the time it works. So, Tamar, you've seen this too. It works. It works.
And this is what's frustrating about it, John, is that it does work. And it's the biggest misnomer in disability law that we have ever seen, because the courts won't look at it this way. Lawyers won't look at it this way when we put them in the insurance company's lawyers' hands. And so why is it that adjusters are keep doing this? Is because these marching orders allow them to deny claims out of the gates or to deny down the road when they're very focused on this idea of totally disabled. The other part of this as well is just an add-on to Sivan's really helpful analysis is this idea of functioning at your job. Adjusters are obsessed with function. In fact, they will do routinely, when you apply for long-term disability benefits, they will routinely look at your function by doing what's called a functional telephone interview. And they actually call it that. And they will actually ask you a breakdown of questions of things that you're doing day to day which has nothing to do, by the way, with the test of totally disabled, because the test isn't if you can go out grocery shopping or if you can take care of your children. The test is, can you do the essential duties of your job? So I think if you're listening out there and you're thinking, yeah, I can go grocery shopping, I can take care of my kids, it must mean I'm not totally disabled. Please don't hesitate to make that phone call. Talk it through with us, because there are nuances to this analysis, even though adjusters like to have this bludgeoning of, you're not totally disabled, you're not functioning, where you can function, you should be able to work, we're going to deny your claim.
Reason number 2, let's get through this one, says there's a lack of objective medical evidence and documentation. All these terms we hear every week, right?
And look, I'm itching at this one because it really does correlate somewhat to what we were talking about earlier in our show. This idea of objectivity when you've got an inherently subjective claim, okay? So this term, objective medical evidence, this does not appear in any disability policy that I have seen. Okay, and yet I will see it routinely included in most denial letters that say, look, we don't think that there's sufficient objective medical evidence to support your disability claim. We are denying your claim on that basis. And this type of denial we see, John, in cases that are like fibromyalgia or chronic pain or mental health conditions. Those are inherently subjective claims. They cannot be tested in the same way as a broken arm would be tested, but they are absolutely valid disability claims. They are warranting of LTD benefits. And so I get frustrated when I see these terms being used as almost a sword as opposed to a shield for the disability insurer to deny otherwise valid disability claims.
We are talking the 3, well, not the 3, but 3 out of a billion common reasons that LTD will be denied for you. Number 3, I'm going to give this one to you, Sivan. Number 3, you can do another occupation that's perhaps sedentary. How about that?
Right. So what people need to understand is that under most LTD policies, to get LTD benefits for the first 2 years, the test is, can you perform the essential tasks of your own occupation? Beyond the 2-year mark, to get benefits beyond that, unless you have a special rider, we see that usually with professionals and certain income earners, the test changes. No longer is it, can you perform the essential tasks of your own occupation? It's, can you perform the essential tasks of any occupation for which you are suited for by training, education, or experience? And so typically, that's when we see around that 2-year mark, or just before that, when we see the insurance company starting to gauge, maybe ask you for a copy of your resume, maybe do some kind of an assessment, a vocational assessment, trying to figure out, can you do something else? And then, of course, you know, they come back and tell you, yeah, we think you can do this profession and this profession. It doesn't matter that that pays you a small fraction of what you earned before. It doesn't matter that you've never done those things before, that maybe you took a course in computers 30 years ago, but you don't work with computers now. So, you know, insurance companies will throw that at you. And again, you as a regular person, as a lay person, will think, well, I have no options here. Maybe I can do those things. Maybe I should, you know, pull out the newspaper, start circling the ads and figure out what I can do. Maybe I can be a telemarketer from home. Now, we do have an extra layer of complexity, I think, we can call it that, since COVID, when many jobs have gone remote. But look, when somebody is depressed, as an example, doesn't matter if they're depressed at work or depressed at home. Their depression, if it prevents them from working, will continue preventing from working. Doesn't matter if the job is from home or not. Doesn't matter if it's sedentary or you know, if you have to pick up something. So, you know, the reality is that the analysis still stays the same. Can you perform the essential tasks of your own occupation? And it's a functional test. We have to figure out, can you perform those tasks, whether it's a sedentary job or a non-sedentary job. And beyond that 2-year mark, or around that time period, that change, we have to figure out, well, can you do something else that will effectively earn you 65%, let's say, of your pre-disability income, commensurate income. Essentially what you're getting right now from your LTD. Can you get a job that pays you that, for which you have training, education, or experience? And many people will come and say, no, I can't, or yes, I can. And so that's where the analysis is. And you know, it's important here that we're going through these denials. And in fact, if you go to one of our websites, ltdfaq.ca, there is a short memo, it's a free memo that outlines some of the most common denials, many more than just these 3. Yep. Because again, people look at these, they look at terms like objective, totally disabled, another occupation. You know, the insurance company will throw the stuff at you. And from a logical standpoint, you may say, okay, well, I don't know this industry. Maybe the insurance company is correct. I mean, they do this for a living. Look, when the insurance company communicates to you, when your adjuster communicates to you, and that's not just with LTD, it's with home insurance or travel insurance or whatever, you have to understand that even though the insurance company is supposed to be there for you, even though you have a policy in place, an insurance policy, and it's there for your peace of mind, the reality is that the insurance company is in an adverse position to you. They don't want to pay you. So if they're giving you any reason why they're not going to pay you, you have to double check it. You cannot simply believe them. You cannot follow blindly. I am telling you, each and every day when we speak with individuals out there across the country, we identify mistakes that insurance companies make, and sometimes it's more than a mistake. Sometimes it's almost obvious that the insurance company is trying to mislead. So again, make sure you check. Don't wait on this stuff. There are limitation periods, and it's really, really important to understand that if you have any questions whatsoever, it will cost you nothing to reach out and speak with any member of our team.
We've got a short break. More coming up. We'll get into that now. In the meantime, that phone number, 1-855-821-5900. This is the Disability Law Show. Stand by.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Welcome back. Disability Law Show. John Scholes, Sivan Tumarkin, Tamar Agopian joining you again this week. There's yet another website you can use anonymously and freely to ask questions, mydisabilityquestions.com. We'll get to one, guys, to wrap it up today. Matthew says, I'm currently on LTD due to arthritis in both my knees and hip. My insurance adjuster has been pushing me to return to work, but I do not feel I am physically capable of doing the job despite ongoing physiotherapy. I previously attempted a return to work program and was unable to make it through. What can I do?
So this is a common type of email that we receive and question that we receive because you can see that this is a pressure tactic that insurance companies use routinely, John. They want to pressure you back to work, especially if you've tried to return to work before. They want to push that envelope in order to get people to get back so that they don't have to pay you. That's really what it comes down to. But in situations like this, I always advise people that they really do have to follow medical advice. It's not even a legal question in my mind. It's a medical question, one where Matthew's own doctor should be advising, look, are you ready or are you not ready to attempt another return to work? Because the last thing you want to do is get back to work, you're feeling better, and then you perhaps find yourself again disabled and not able to continue working. You're going to have that much more resistance from the disability insurer having gone back because they've stopped paying you, and now they get a little taste of not having to pay you, and they don't want to deal with a recurrence claim potentially or further LTD benefits on this basis. So in my mind, that's the starting point, is not to buckle to that pressure to return to work unless your doctor clearly gives you the green light to return and make that attempt. And even then, I would be very cautious, do it gradually, make sure your own medical team is involved throughout the whole process so that you're getting the support that you need from someone who cares and not the insurance adjuster that just wants to cut you off and stop.
It's always a medical team, right?
Absolutely.
Always a medical team. And that is it for another show. Thanks, guys. Awesome stuff. You can always reach out now that we're done anytime. A few different ways. That phone number first, 1-855-821-5900. That was from mydisabilityquestions.com. And email help@disabilityrights.ca. Thank you so much for joining us, and we will catch you next time right here on the Disability Law Show.